Well, good morning, America, and welcome back to the Rhine Report. Today's topic is, the title would be, The Clash Between Posse Comitatus and the Insurrection Act. Now, get ready for this colossal movie coming to your neighborhood theater. I jest. What else can I do? Here are the present facts. As I've been predicting for several years, we are heading for an invocation of the Insurrection Act, and while no court case has ever overturned posse comitatus, which we'll discuss, the Insurrection Act is said to be the only law that supersedes or is an exception to posse comitatus. Confused? It gets worse. Moreover, recent cases involving the Nazi Trump dictatorship have been brought not under the Insurrection Act, but under a more restricted statute, which is 10 U.S.C. Section 12406, which I have discussed ad nauseum in other podcasts. These cases are being brought in California, Oregon, and Illinois, where trial court judges are upholding the law and have held that this particular statute does violate posse comitatus, and should this judgment withstand appellate court rulings, then the Emperor Trump will absolutely go straight on to the Insurrection Act, which is 10 U.S.C. Chapter 13, Sections 251 to 255, as a means to defeat posse comitatus, because, as I have said, it appears to be the only exception to the Posse Comitatus Act. So, first there is the Posse Comitatus Act of 1878 to discuss, and here is its background. It was enacted, as I said, in 1878, following the Reconstruction era, and the act generally prohibits the use of federally organized military forces to perform civilian law enforcement duties, such as arrests, sieges, and searches. It is a statute under criminal law and punishable by fine and/or confinement in prison, I think for up to 2 years. There are congressionally authorized exceptions to the act, most notably the Insurrection Act, which permits the president to deploy the military domestically in specific situations of rebellion or civil unrest. So, the Posse Comitatus Act applies when the National Guard is called into federal service under Title 10 of the U.S. Code, but interestingly, not when it is operating under state command and the governor remains in control. This comes up later in this discussion. Now, as I said, the main congressional exception to the Posse Comitatus Act is the Insurrection Act, which does permit the president to deploy the U.S. military for domestic law enforcement under these very specific circumstances. The Insurrection Act, being invoked, allows the president to use the armed forces to suppress insurrections at the request of a state legislature or governor, enforce federal laws when normal judicial proceedings are insufficient, or to address domestic violence or conspiracies that prevent people from exercising their constitutional rights. The latter provision was used to enforce school desegregation during the Civil Rights Movement following Brown versus the Board of Education. It was originally titled the Insurrection Act of 1807, but it now comes under 10 U.S.C. Chapter 13, Insurrection, from Title 10, Armed Forces, Subtitle A, General Military Law, Part 1, Organization and General Military Powers. And the sections involved here are 251, 252, 253, 254. We are only concerned with sections 252 and 253. In 252, titled Use of Military and Armed Forces to Enforce Federal Authority, it reads, when the President continues to consider that unlawful obstructions, combinations, or assemblages, or rebellion against the authority of the United States make it impracticable to enforce the laws of the United States in any state by the ordinary course of judicial proceedings, he may call into federal service such of the military of any state and use such of the armed forces as he considers necessary to enforce those laws or to suppress the rebellion. To me, in the first sentence of 252, it may allow presidential action under quote-unquote unlawful obstructions. You can argue against it on the grounds that the obstructions are lawful, and also it would seem to be reliant and conditional on the definition of the included phrase, quote-unquote, impracticable to enforce the laws of the United States by the ordinary course of judicial proceedings. The ordinary course of judicial proceedings, by definition, refers to the normal, customary, and expected path a lawsuit takes from the initial filing to the final judgment. It is the standard process of a court resolving a legal dispute, including all the procedural steps and actions taken by the parties involved, rather than any exceptional or unusual circumstances that might arise. Therefore, 252 may be voided if normal Article 3 courts are available to enforce the laws, and 252 does not state that protesters exercising their rights to free speech and assembly are necessarily obstructing law enforcement. You would need an evidentiary showing here. The President, by using the militia or the armed forces, or both, or by any other means, shall take such measures as he considers necessary to suppress in a state any insurrection, domestic violence, unlawful combinations, or conspiracy, if, big if, 1. so hinders the execution of the laws of that state and of the United States within the state that any part or class of its people is deprived of a right, privilege, immunity, or protection named in the Constitution and is secured by law, and the constituent authorities of the state are unable, fail, or refuse to protect that right, privilege, immunity, or to give that protection, or 2, opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. So, disregarding 1, which can be successfully argued against, there is a big problem with 2, because we are now down to a showing of a mere opposition or obstruction of the laws as a sufficient pretext to invoke the act. Now let's deal with Section 253, which is the interference with state and federal law. The President, by using the militia or the armed forces, or both, or by any other means, shall take such measures as he considers necessary to suppress in a state any insurrection, domestic violence, unlawful combination, or conspiracy if it, 1, so hinders the execution of the laws of that state and of the United States within the state that any part, this is a repeat basically of 252, or part or class of his people is deprived of a right, immunity, privilege, or protection named in the Constitution and secured by law, and the constituent authorities of that state are unable, fail, or refuse to protect that right, privilege, or immunity, or to give that protection, or 2, opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws. Again, 253, 1 basically is repetitive from 2521, but now we have the added word opposes in 252, Section 2, which seems to be an unconstitutional abridgment of protected free speech and assembly, and opposition is not the same thing as obstruction. In any situation covered by Clause 1, the state shall be considered to have denied the equal protection of the laws secured by the Constitution. Weary making, isn't it? Just to make this clearer, I've used a New York City Bar Association call for executive restraint and congressional clarification, and I'm going to read from their paragraph. Using the Insurrection Act to override the protections of the Posse Comitatus Act and deploy U.S. troops within the United States to investigate, detain, and remove illegal immigrants would be an unprecedented use of presidential power and a misuse of the military. Such action runs contrary to the Insurrection Act's plain language. While there are serious issues with the current immigration policy that need to be addressed, those issues cannot be equated with, quote-unquote, unlawful obstructions, combinations, or assemblages, or rebellion against the authority of the United States, unquote, that are required to invoke the Insurrection Act. Nor can the incoming administration show, and now they're here, that illegal immigration has made it, quote-unquote, impracticable to enforce the laws of the United States, unquote, or that use of the military is, quote, unquote, necessary to enforce its planned immigration policy. So, another thing to consider in all of this mess is, and I'm bringing you something new here, under Title 32, which establishes and affirms the National Guard units are controlled by their respective state governors by default, while the Guard remains under state control and command, the Posse Comitatus Act does not apply. Why this is so, I have no idea. But parenthetically, nor does the Trump regime control anything. So, back to 10 U.S.C. 12406, because that's the present legal issue, under which the president may place a state's National Guard under federal command if he can make a showing that satisfies one of three prongs, and I think we're dealing with prong 3, that he's going to claim and has claimed that he is unable to enforce federal law with existing forces. Now, once federalized under Title 10, the National Guard personnel are treated as active duty military and become subject to what? The Posse Comitatus Act. Please note, all of you folks, that only prong 3 can it be reasonably argued with any chance of success by President, Emperor, Dictator Trump, because it infers the court's so-called obligation to offer judicial deference to the president in his consideration of the facts, and presents a great danger to the outcome if it gets incorporated into the court's reasoning, because his assessment of the facts may be Looney Tunes, it may be pure fantasy, it may not comport with the actual facts on the ground. As one judge has already said, it is untethered to those facts. So, separately, and this is interesting, under 32 U.S.C. Section 502F, the President or the Secretary of Defense can request, not order, that a state governor issue orders for members of that state's National Guard to perform duties including law enforcement functions. However, in this case, the National Guard remains under the control of the governor, and the governor retains legal authority to refuse the request, because the Guard remains under state command in Title 32 status. The Posse Comitatus Act does not apply, but our Nazi regime fails to take over. The streets of our cities are safe and saved. So there we have it for the moment in this time of sorrow, and where we're subject to further legal issues and litigations that from the Nazi president's perspective are aimed at one thing, and that is at achieving military control in the streets of our cities, and we all know the reasons why he would want to do that. Thank you for watching.